I think we might have one online. Then maybe not. Nope, no hands raised.
Hey, if there's no comment, we'll go on to the chair report. My name is Dr. Terry Murphy, and this is the first meeting I'm officially chairing in the chair capacity. I've been on the commission for about 6.5 years, representing District Number 4. My background is in emergency medicine. I've been in healthcare for 46 years this year. First 20 years as a nurse and clinical nurse specialist, and then as a board certified emergency medicine physician. I have no agenda as chair except to serve the state of Washington and give back to the people and the providers. And then finally, I would like to thank the executive committee, and in fact, mostly thank Dr. Karen Domino for her 2 years of leadership. Thank you. Okay, item 4 is the consent agenda. Items here are listed in the packet and are considered routine agency matters and approved by a single motion unless there's concern for separate discussion. There are 2 items, the agenda and then the minutes from May. Are there any concerns, or can someone make a motion to accept the consent agenda and minutes as listed in the packet?
I move to make a motion to accept both of these things that are in the packet.
I second.
Thank you. Any discussion? Hearing none. All in favor say aye or raise your hands.
Aye.
Aye.
Any opposed? Motion carries. Thank you. Under new business, DOH letter regarding the 2025 World Cup events. Mr. Kiernan.
Thank you, Dr. Murphy. This was something that came through the commission, but it's not something that you as commission members see or hear very much about. So I thought I would include it for your reference. This was with regard to the Club World Cup that was recently held in Seattle that attracted a number of teams from across the globe, international soccer. I think it's reasonable to anticipate that the department will do something similar for next year's actual World Cup between nations, not professional teams. But it was an important reminder as I talked to DOH about this, because the initial inquiry came into us. And I wrote a little bit about this in the last newsletter, but it's important to remember that the commission does not enforce standards around what is unlicensed practice of medicine. That's done by the secretary. We encouraged the folks who are organizing the Club World Cup to consult with the secretary. A number of states have been approached about this, and it's basically teams that are bringing their own physicians with them who might be providing medical care while they're temporarily in the state of Washington. So I thought I'd include it as a reference, and if there are questions, I can certainly answer them. But I think it's important to kind of remember the role that the commission plays and the partnership and occasional collaboration that the legislature has set up for us with the Secretary of Health. So in this particular case, the secretary is going to use their discretion and not enforce licensing requirements for international physicians traveling with the soccer teams who will be visiting or who visited Seattle in the month of June for the Club World Cup. That's the kind of short version. Again, I'm happy to answer any questions. This is really just an FYI and a reminder that sometimes the scope of the work that we do for the commission interacts with the secretary. And again, it's kind of exciting to have an event like either the Club World Cup or the World Cup in Seattle. So with that, it's really just an informational piece. If you have questions, I'm happy to answer them. Otherwise, we can move along.
Are there any questions for Kyle? Yes.
Just for clarification, the international physicians will be just providing care to their teams, not to anyone outside who's not their teams.
That's correct. Yeah, it's team-based only. A lot of teams bring with them a whole suite of healthcare providers, not just doctors, physical therapists, massage therapists, athletic trainers. It runs the whole gamut, and it's quite an event. But they're limited. The exemption is limited as long as they're here in the state of Washington to providing just those members of their team, or next year, likely their country.
Any other questions?
Thank you.
Okay, next item is the commissioner retreat for 2026. Amelia, are you talking about this?
Yes. So I provided some dates for you to vote on to choose which day you're going to meet as a group of commissioners to do your retreat next year. We won't be holding one this year. We had to cancel the one that was in April because it interfered with some other things going on for commissioners. So I just wanted to present some dates, and then in the packet, you can see how those dates would interact with the other meetings that we have going on and holidays and things of that nature. So that's just my request here today, is that you pick one of these dates and as a group majority, decide which one you would like to schedule for your retreat next year.
Amelia, I was just looking on my phone to see if I had stuff there, but I do have it in a calendar that's packed in my suitcase in the car because I do travel. So if we could, I mean, otherwise you guys can pick it and I'll see if I can come. But anyway, I don't know if other people have any issues finding out what they're doing next year.
I would just say that in June, we have no commission meeting. And the weather should be rather nice on the west side. So that would work out best for me.
Dr. Murphy, we specifically, when Amelia and I were talking about this, we're specifically setting this up for a Thursday. That's not always the way we've done it, partly because we're looking at holding the event up in kind of the Seattle area. And the last thing we want to do is be putting a bunch of you all out into Friday afternoon traffic, trying to get back to the airport or get back to wherever you're going. And so that's the reason that we're looking at Thursdays. The space that we're looking at using is in Kenmore, which is kind of north of Bellevue for those who haven't been up in that area. It's a relatively new facility. Amelia did a site visit. It looks perfect for what we need and what we have in mind. But we just need a date.
Can I just suggest that you send out maybe like one of those doodle polls or something so we can all have a chance to look at our calendars and then respond by email or some way so you can see the majority? I don't know, something like that. This feels like we need time to.
Is that okay, Heather? Like proxy voting? It's a meeting.
So they can communicate with you, just with you directly on the dates.
Okay.
And then you could bring it to the next meeting and just have them vote to confirm whatever is the majority.
I will do that. Thank you.
Amelia, I just want to say that I agree with the June 11th since we do not meet then and the weather is great, and appreciate you doing that site visit for another spot for us to go.
That is a fun part of my job, going to do site visits.
So thank you.
It looks like Dr. Wones, if you'd like to make a comment.
Yeah, just as a segue from the FIFA World Cup discussion we just had, there are 6 dates next summer, 2026, where the World Cup events are going to be held in the Seattle area, and the traffic's supposed to be horrible. So did we verify that none of these dates, like the June, July dates, particularly for the commissioner retreat, possible dates listed, are they clear of the FIFA World Cup events? Do we know that?
No, we did not review those dates, but I can do that.
Yeah, I might want to do it because traffic really is supposed to be bad. But thank you very much for doing your work on this. Look forward to it.
Sure.
Yeah, those dates are listed. But we can defer this to a doodle poll. I think that's a good idea.
Yeah, we can certainly do that. Thank you.
Thank you. Next item is 2026 request legislation. Mr. Matthews.
Good morning, Commissioners. So this is part of the usual process of developing request legislation. In the packet on pages 42 through 47, you have some briefs about what we intend to develop as far as request legislation. One of these is a repeat from last year. So you've seen this. That's the relinquishment of the license. Currently, you have to have a STID or an agreed order to give up the property right, even if there's no investigation or discipline required. This is something that we've talked to Dr. Bundy and WPHP about, and they have expressed support. The model would be asking for rulemaking authority to conduct rulemaking in each of the chapters to establish a process to relinquish the license back should someone choose to voluntarily do so. That's coming at the request of one of our professional associations who doesn't want to see their particular chapter opened up so early after the adoption of said chapter. So these will be taken as individual votes. So I'll just go through the other two. The first one is the Open Public Meetings Act revision. So really, it's just clarifying that virtual attendance is an option. I think Amelia can speak to exactly how many meetings we've had that are virtual that no one has attended, but we've had to either rent out a space or secure a space here and have a staff member sit by an open phone line in case someone shows up. Obviously, that's a little frustrating from an operational and resource standpoint, but I understand the issue is it's not explicitly allowed, I believe, as far as being able to do that. And since you do have virtual meetings a majority of the time, this isn't going to be a, excuse me, a degradation in attendance for the public. It's just simply stating that you have a phone line, you have a Teams link, you can virtually attend either way. And conveniently enough today in what's the Washington State Standard, which is a news organization that looks at the government of Washington State, they noted frankly, and this is a technical term, a ridiculous increase in public participation from 2019 to current once the legislature opened up virtual attendance, like going from tens of thousands to hundreds of thousands. So it really is the way of the future on that. So if I could get a motion and a vote to allow us to develop that and take it forward for request legislation, I'll take that now.
Any questions for Mr. Matthews about the pursuing the Open Public Meetings Act revision? Either in person. Go ahead.
Clarification, do you need a motion for both of those items? or-
One at a time, I think he's
Because I
seeking.
didn't want to do it on a consent in case one got opposition, we're doing individual votes. So technically 4 individual votes. I'll get to the.
I know, but I know that should be individual, but I just wanted to make sure you needed, you're requesting a motion for both.
Yeah, I'm requesting a motion for it right now for the OPMA Act revision.
Okay, so moved.
Moved and seconded. Any further discussion? Hearing none, seeing none virtually. All in favor, say aye or raise your hand.
Aye.
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 Any opposed? Motion carries.
Thank you. And if we could move on to the relinquishing license development piece and get a motion for that as well.
Okay, any questions for Mr. Matthews about that? If not, can we have a motion to approve relinquishing of a license legislation? Second. Thank you, Ms. Blake. Multiple seconds. Any further discussion? Hearing none, all in favor say aye or raise your hand.
Aye. Aye.
Any opposed? Motion carries.
All right. And so the third of three of four items is the certified anesthesiologist assistant surcharges. So when that law passed, I believe it was 2 years ago, there was implied authority for WPHP surcharges, and there was an omission of authority for the HEAL law surcharge, which is to access the University of Washington Health Library. So that the latter one was just a flat out omission. The other one, Heather fought valiantly for to get us to have it included in the Secretary of Fees. We were overruled. So now we're asking permission to develop a technical bill to go and explicitly fix that. Part of that is to just with respect to the HEAL law fee to say anything under the purview of the medical commission has authority to have the HEAL law charge. So we'll future proof any future issues there. So any questions?
Any questions for Mr. Matthews?
It wasn't opposed. It was omitted. It was just a technical drafting error on the part of the proponents.
See no questions, so can we have a motion to pursue that legislation? Thank you. Moved and seconded. Any further discussion? Seeing none, hearing none, all in favor, say aye or raise your hand.
Aye.
Any opposed? Motion carries. Thank you.
All right, and the final item is a late breaking one. This is not a request legislation. This is authorization to develop a decision package, which is how we ask for additional spending authority. As we've discussed in numerous venues, we do have the appropriate reserve and finances to support this. But what we've been experiencing is, and executive committee knows this, we've seen an increase in complaints total received. Your authorization rate has maintained at a stable rate, which no matter how we look at is an increase in investigations. Our investigators, clinical or not, are all incredibly productive, but it's a math problem we can't solve without another position. So the decision package is to add a clinical healthcare investigator. It would they would not come online should you approve this. They would not come online probably for about 18 months.
So this is not legislation, it's just a request to add an FTE?
It's so in order for us to get the spending authority to do so and the FTE allotment, we have to put forward what's called a decision package. It's a budget request, in other words. And so that is included as part of the overall state operating budget.
Okay.
So we have to ask both for the funding allotment as well as the FTE count.
Dr. Domino, did you have a
No, I was just going to say, I move ahead with this budget decision request.
Any further discussion? Yes, Mr. Lopez.
Mr. Matthews, could you explain why it takes 18 months to get somebody?
Sure.
I'm a dummy. I just can't.
I will start with the short answer, and it's called the legislative process. Yeah. I usually don't take 18 months for an answer, but it's happened. So first we have to develop the actual language. We have to get it through OFM, which starts, Office of Financial Management, which starts the process around September of this year. And then if the governor approves it to be included in his proposal for the budget, that happens around November, December. Due to the transition in administrations, it didn't happen until mid-January this last time, which if you're in the legislature, that is far too late to even consider introducing a bill. So once it goes through, depending if it's a short or a long session, that's either March or April that it's adopted and hopefully signed. And then the effective date is generally July 1. And so we could potentially start recruiting before July 1 if it was approved and gotten passed through the legislature. But the fact is getting a clinical investigator recruited and then trained up and effective as much as the ones we have now is usually a 12-month process. So I'm counting from now until they're potentially online and trained up.
Thank you. Appreciate that.
Any other questions or discussion? So it's been moved by Dr. Domino. Do we hear a second?
Second.
Thank you.
Pam?
Hello?
Yes.
Yes, I found it. Thank you so much for waiting. Sorry about that. Okay, so let me just put
I'm
this
so
one
sorry.
here.
This is not public comment. I am so sorry.
Okay. All in favor, say aye or raise your hand. Any opposed? Motion carries.
Thank you.
Thank you. I think we look forward to having another investigator. Okay, next item, Mr. Farrell, delegation of decision-making to health law judges.
Hi, good morning, everybody. So if you have this document in front of you, this is a delegation of decision-making authority to health law judges. This is an old document. It's not a new document. Your predecessors passed this many years ago, but most of you have probably never seen this. So let me spend a minute telling you exactly what this is. You have decision-making authority at just about every step of the disciplinary process. You get together and you make decisions like you did yesterday. The health law judges provide a service to you. You've sat with them at hearings and during other proceedings, and they provided this checklist to you to ask you if you want them to provide other services at the decision-making process. And you've checked these boxes, or your predecessors checked boxes on decisions that are basically non-discretionary. They're ministerial, they're automatic. So for example, I'll just go over the first two. If you see the second box, consistent with RCW 18-13400, when a healthcare professional in our state is found by DSHS to have abused a vulnerable adult, whether physically, verbally, or financially, they have to be suspended initially. It's automatic. I don't think we've ever had a case like that, but if you did have a case like that, you would not have to do the suspension, the health law judge would, and then the case would come back to you, and then you could decide what to do with that person. The second one is something you're very familiar with, and that is when somebody is restricted from practicing in another state, that's an automatic suspension. Sometimes you hear the phrase 370 suspension. That's automatic. You probably had a couple of those yesterday. And what you do is you vote to suspend, and then the process is that it comes back to you. If you hadn't delegated, it would come back to a panel of 3 to look at the motion and the order and meet and sign off on that. Well, that is completely ministerial. It's not worth your time. So a health law judge steps in and takes care of that process, signs that order, looks at the document, signs the order, and then the case comes back to you and you decide what to do with that person. So instead of sending an email saying, can 3 of you please, do you have a few minutes of time next Tuesday at noon? The health law judge takes care of that. So what we're asking you to do today is to add one more item to that, and that's what's highlighted near the bottom. When a practitioner is out of compliance with an order, not a STID, but an order, one option is to issue a statement of charges, but another option is to have a fast track motion. And we've done that a few times over the years. It's a very quick way to suspend the license until they come into compliance. And so you initially vote to go down that path, but we're asking you to check a box allowing the health law judge to sign that order of suspension. Actually, they hold a hearing. The respondent can appear at the hearing and present his or her case. And actually, mostly they get into compliance right away, but sometimes they don't. Sometimes they have a hearing, but that hearing is not held before a panel of you. It's held before a health law judge. We've done that in the past. We're asking you to just make it official, just to make us more efficient. So.
Questions for Mike? Use the microphone, please.
I was wondering how long the person has to be out of compliance before it goes to the judge for the non-compliance.
So if you and I had a case, if we have a case and someone's out of compliance, I would consult with you and say, what do you want to do? And let's say, I want to suspend this license as quickly as possible. We present it to a panel, we'd prepare a motion, and we'd file it. And then the judge would set a hearing date within I think it's a week or two. And then that respondent would be notified. And then they'd have the hearing and the judge would sign the order.
Got it. So really, it's the decision that they're now out of compliance and we're going to do the fast track is made by the panel.
Yes.
And then it goes to the judge. Thank you.
Yes.
So it would streamline the process is what you're saying.
Yeah, all of these are streamline the process for decisions that are really, we don't need your discretion or expertise.
Mr. Lopez.
Mr. Farrell, could you just give me or give us all an idea of the law of unintended consequences on something like this? Or are there any?
I don't think there's any downside at all. Nothing has ever gone sideways. Everything has gone according to plan. You don't lose jurisdiction. I remember presenting this before and somebody said, well, we lose the case. No, you don't. It comes right back to you. After this order is signed, whatever the order is, it comes right back to you. Oh, and the last box, I'll just mention that one is kind of called a catch-all to serve as the final decision maker on a case-by-case basis. So occasionally we cannot find a hearing panel. We can't get 3 people to sit for a hearing. And if that case does not involve standard of care, you can delegate to a health law judge. We don't like to do that, but the health law judge will sit and listen to the testimony and issue the order. And they do a really good job at that. We don't like to do that because we like you to sit for hearings. And we really appreciate the people who do sit for hearings and spend the time and do that. But that's always an option.
Any other questions or discussion for Mr. Farrell? If not, can we have a motion to present this, to approve this? Thank you, Dr. Curry. Multiple seconds. All in favor, say aye or raise your hand. Any opposed? Seeing none, hearing none, motion carries. Thank you. So on to item 6 is old business. The committee and work group reports are written on page 53. Pages 51 and 52 have a list of committees and the work groups. Are there any additional reports?
Good morning, Commissioners. Gina Fino, medical consultant. I am part of the psychedelic medications and behavioral health treatment work group, and I did provide some materials in the packet. I did want to give you a little bit more of an update in person about the challenges that we are facing, just to give you a sense of the landscape. Currently in the United States, both Colorado and Oregon have licensure pathways for psilocybin, one of the psychedelic medications that we're considering in our work group. Those licensing options to provide access for patients to have psilocybin are not through the medical boards, but through public health and licensing departments. Those medical boards have not commented officially on those things, and haven't put out any best practices statements. When I looked across the country, the only states that have best practice statements about psychedelics are Pennsylvania and New Mexico, and those are for ketamine. There are some challenges to putting forth best practices, and if you'll indulge me a little bit, substance use is part of the human condition. And as medical professionals, we're no strangers to modifying the serotonergic system. Just thinking about SSRIs, selective serotonin reuptake inhibitors. Again, here's where you need to indulge me. When I think of those, I think of a vacuum cleaner in the brain, cleaning up serotonin and recycling it. An SSRI is like a clogged vacuum cleaner, so that serotonin stays around a little bit longer. When I think about psychedelic medications in the brain, most of them are serotonin impersonators or other neurotransmitter impersonators. I think of them as trick-or-treaters dressed up like serotonin that have a lot of candy. And when you give trick-or-treaters a lot of candy, sometimes they throw up. And then you have to deal with it. And the literature right now isn't really great about telling us how to deal with that. So this is where my struggle is to come up with best practices. On the one hand, from a patient safety point of view, it seems like we should have done this yesterday. The challenge is every time I find some research, Marnie's has a background in psychiatric medication management. She's really good about pointing out the flaws in the studies that I've found, whether they're testimonials, observational, lack of controls. But we're working on it and we're getting closer. What I would like to ask you is, do you think this is worth pursuing? Would you like to take a step back? Would you like me to get more information? Maybe refine my trick-or-treater analogy? I'm happy to do what you would like. There's not a lot out there to model. This would be something that would probably be the first of its kind in the States. Dr. Domino, would you like to comment?
Oh, yeah, actually, I'm supposed to chair that committee, so I was wondering about what was happening with that. But have you looked into Canada for some of the information? I went to a meeting in March, and it was dealing specifically with psychedelics. Not the whole meeting, but it was a session, a 2-hour session. And it seemed like the Canadians have done some work. Of course, the quality of the research is largely, it's hard to do a randomized controlled trial in this. What they do is they give them a smaller dose. So they still have some hallucinations, but not for that 6-hour therapy period they have or more. So they obviously probably can tell there is a difference, even though they are randomized studies. And what they were pointing out, it's first of all very difficult. That's why the literature is poor. People are trying to do it. There were Canadians somewhere in Toronto or somewhere in Ontario who are working on it. And that they thought that a lot of the thing is the engagement of their system was 6 hours with the therapist. And they said that it was challenging for the control people to spend 6 hours with a therapist. But that therapy part of it was such an important part that they thought. So I'm wondering, I can look up and see who these folks are, but I thought, hey, maybe they have some models in Canada because they've been using a lot of this stuff. Stuff has been legal there for a longer time than here.
I have not specifically addressed that, but if you would like me to pursue that, I'm happy to do that.
I can get you some information or I'll contact the people and I know them.
Wonderful, wonderful. Thank you. Dr. Curry?
So I was going to make a suggestion, Gina, and thank you for including all the stuff in the packet. It was interesting to read it all. It seems to me that ketamine is a little further along in the research side of things. And my suggestion was going to be to maybe piece out the ketamine part of it, that doing some best practices or guidelines for that might make a little bit more sense at this stage of the game.
Okay.
Because there are universities around the world that have started programs in psychedelics, MNDA, whatever, and psilocybin, et cetera, LSD, all those things, but it's not nearly as developed and as far along. Not that ketamine is super far along, but it's better than the other. So I was just going to make that suggestion to maybe separate.
Yeah, I would agree with that too. The one thing I did find interesting is that the Texas board made ketamine an anesthetic. Okay, I know psychiatrists are administering it, but you're starting to see people around, giving these drugs like it parties at, you know, concerts, you know, outdoor concerts and other things. There are compounding issues. The thing that I went to the meeting and again, it was in the spring that the commission sent me to, which is a joint nursing, pharmacy, and Federation of Medical Boards meeting, was amazing about the sort of the compounding issues. I mean, there's same compounding issues are with the IV medications as well, but it is complicated, and who should prescribe it? I mean, you know, and the way that they got around with the anesthetics is it ended up being an office-based anesthetic, because you don't do anesthetics outside that. And it's my father did the original work on ketamine, you know, and I know that, you know, the psychiatric uses have been helpful. It is still an anesthetic.
Anyone else? I really appreciate your help and support. Lopez.
Dr. Fino, I want to thank you for your commitment to this work. It's clear that with the demand for mental health care and support in our country, that more and more providers and patients are seeking the help and the support for treatment. And psychedelics are becoming much more popular, as you know. So I think that the sooner we are able to find out more about effects and how to manage and or regulate this, the sooner the better for the safety of both patients and providers as well. So I support whatever it is your commitment you're doing. And certainly if I can be of any help to you, I work in a psychiatric center 2 or 3 days a week on the inpatient side with as a medical consultant. So I'm happy to help if I can.
Thank you so much.
I just had one other comment that made me remind of one of the side effects. You know, ketamine has addictive properties, and it's really something to think about. Apparently, my father did a lot of traveling in Asia, and he was saying that there are a whole bunch of ketamine addicts in Japan and in China. He said before he died a couple years ago that's really an issue. And so having it, you want to treat the mental health, but you want to be safe. And that's the whole thing. This is a, you know, an issue down there, and you need to, I mean, I think we just need to consider that aspect and what's safe for people, in addition to what works.
Great. Thank you. Any other comments in the room or virtually? Okay. Well, thank you for the efforts, and we'll continue to explore. Thank you. Onto the rulemaking process, Amelia.
Thank you. So we do have a rule and process for our MD chapter, and we will begin holding workshops soon. We do have one scheduled for September 8th, but I'm going to need to reschedule that. So I am just looking for volunteers to be part of the committee for that particular rule. We are excluding the opioid prescribing rules from that chapter because they're open under another rulemaking effort. So we're just going to be addressing the rest of the sections that we mentioned here. We're also excluding the office-based surgery section because it's open under another rulemaking effort. So I just need some volunteers that I can reach out to schedule those workshops.
Do we have anybody that can volunteer now?
Can you go into more detail about what specifically it is? It's just medication? Is that what it?
No, it's the whole, excluding those two sections, the whole MD chapter. So it's licensing, definitions, so things like that. Yeah, it's the whole chapter. Thank you, Chris. And then if you don't want to volunteer right now, you can always email me after this meeting.
I think some people might need to check their schedules.
Sure. Thank you.
Thank you, Dr. Chang. So you got 2 volunteers.
Perfect. I only need 3, so
Yeah.
just one more.
everybody check their schedules and email Amelia if you can help. Okay. On to the next item, rescind the rulemaking approval.
So as in the packet, I do state that you approved doing rulemaking to define qualified physician as part of the optometrist change in scope of practice. You did that back in late 23, but in the meantime, we've had it on hold because there was a sunrise review and other things that happened. So, and they have changed their scope of practice. And we do have an interpretive statement that you have adopted some months ago. And what we are planning to do now is rescind this rulemaking approval, and we are going to include that interpretive statement language in the chapter that we just talked about. And so we don't need to do separate rulemaking on that anymore. And so my request is just to rescind your approval. We haven't filed anything for that rulemaking because it has been on hold. So that's just my ask today, is that you rescind that approval.
Because it's covered
Right.
somewhere else.
We're going to include it in the MD chapter.
Okay. Any questions for Amelia on that? Can we have a motion to rescind as requested? Thank you. Multiple seconds. Any further discussion? If not, all in favor, say aye or raise your hand.
Aye.
Any opposed? Motion carries. Okay.
Just the delegate.
So Amelia, this next item, do I need to have Dr. Domino cover it, or can I cover it?
Sorry about that. Dr. Murphy, you can take care of this.
Okay. The next item is just changing the name of the signature authority for credentialing, disciplinary, and rulemaking, as is customary with a new chair. Any questions, comments?
There are numerous points in our processes where we have to sign off and show some level of legal formal approval. We don't want to be inundating Dr. Murphy any more than we already do, or Dr. Domino before her. And so this is simply saying it's okay in these circumstances for staff to sign on behalf of the commission. Heather, I don't know if there's anything else you want to add?
So if there's no question, can we have a motion to change that thinking, the language? All in favor, say aye or raise your hand.
Aye.
Any opposed? Motion carries. On to lists and labels request. Heather?
So you have one request from the Contemporary Psychodynamic Institute. They are asking for lists and labels, and they have checked that they are an educational organization, which is defined as an accredited or approved institution or entity which either prepares professionals for initial licensure in a healthcare field or provides continuing education. I note in the packet that they also requested other secretary or the psychologist and other secretary regulated profession, mental health professionals. It appears from the materials that those professions have denied the list and label request. And it appears that it may have been appealed for a BAP, but I'm not sure on the status of that. In the materials, I do not see any accreditation or approval by any entity that would grant CME credits. So based on that, I don't believe they beat the definition of educational association.
Any questions for Heather? That information is on pages 145 to 159.
It says CEU. I don't know what that is. That's under.
Units. Yeah, so it's different than CMEs.
Yeah, I know that. I didn't know if it had some other psychiat or psychology thing. Okay, thanks.
So Heather is recommending that we deny this request. Can I hear a motion to do so? Thank you. Christine, second. I think I saw multiple seconds. All in favor, say aye or raise your hand.
Aye.
Any opposed? Motion carries to deny that request. Now we turn to the policy committee and Ms. Blake.
Thank you, Dr. Murphy. As hopefully you've had an opportunity to go through these documents as well prior to this meeting. We are asking for deferral of one of our documents, which is a guidance document, collaborative approach to reducing medical error and enhancing patient safety. We'd like to put a little bit more work into this, so we're requesting that it be deferred. If all of those that approve that deferral, please raise your hand. I think Micah has, it looks like Micah, okay. All those that approve this deferral, please raise your hand. And it looks like we have a hand raised. Oh, they're voting, sorry. Yeah, thank you. Any opposed to the deferral? Thank you. Our second document, I don't know if Ms. Katichju is here.
She's online.
Oh, okay.
Yes, I'm here.
Thank you. The second is a guidance document on medical professionalism, and it was reviewed as part of its 4-year review process. And we recommend approving it with the noted amendments. Ms. Katichju, did you want to make any comments about the amendments?
Yeah, sure. Good morning, everyone. My name is Khadija Kera, and I'm the new policy manager. So it's nice to meet you all. And on the medical professionalism document, we did some amendments before. So when I first started, Micah gave me the documents where the Washington Medical Association had some recommended languages that they want us to incorporate. And that was like, if you're looking at the document, you will see it is part of professionalism is being aware of the unconscious and the conscious bias, and that practitioners must be sure to treat all patients with compassion, equity, and respect. So we added this before our policy committee meeting. So during our policy committee meeting, Dr. Bundy also added some proposed language that he think will further reinforce the commitment to professional responsibilities. So he added that, and I sent it to Miss Blake, and she also edited it further. So this last part is the final edited version of what we have from the edits that were made by the Washington Medical Association, and also the suggested language from Dr. Bondi, and also the edits that Miss Blake made. If you approve this language, or if you want us to change anything or like that, we can go ahead, Miss Blake.
So this is more a question for Amelia. I know we've got a comment. I'm not sure how we address that.
So we did receive a comment, however, that comment that from the P3 Alliance, and that comment was included at the last policy committee meeting. It was considered there. You can consider that comment today if you would like. You would have to probably bring it back to a future interested parties meeting and then the policy committee again, if you would like to do that. That way there's a chance for the policy committee to discuss the changes. But you can consider that comment. It's, I don't remember what page it's on, but it's towards the end of the packet.
Dr. Chen.
Yeah, thank you. At the risk of sounding overbroad, I wonder if it would be more appropriate in the amended portion to say that practitioners are obligated to treat everyone with compassion, equity, and respect, not just patients, because they have to be interprofessional, which means they also have to treat their colleagues, nurses, other stakeholders with the same amount of compassion, equity, and respect. I think there is some level of issues with practitioners having unconscious bias in the way they treat each other that needs to be part of professionalism. So I might make an amendment if that might be treated as a friendly amendment, but it does, in a way, materially change the meaning of the addendum. So
Agreed. Great point.
Yeah, and I like that point too. Excellent point.
Dr. Curry.
I read the P3 Alliance comment, and I feel like the statement about professionalism being aware of conscious and includes being aware of unconscious and conscious bias kind of covers the issue of chronic pain patients that they were concerned about. I don't know if it needs to be called out separately, since there are so many categories of that, right? So I just, for what it's worth.
Thank you.
Yeah.
Are there any other comments, either virtually or in the room? Can we approve this here with the amendment Dr. Chung suggested?
can I make a motion to add the amendment and then you can vote on the entire document? I think that's the right order of. So I'll make a motion to change the amended portion to say, treat everyone with compassion, strike out all patients.
Mr. Matthews, did you have a comment?
I just wanted to get the specific language before a vote was.
Okay, thank you. If there's agreement to that, may I see a show of hands, please? And it looks like we're raising hands virtually as a vote, so thank you. Thank you for that. Our next document, and I just have to flip back because I.
A quick point, do we not have to now vote on the entire document?
Yes, we just did.
I was just making the amendment.
Okay, then may I have I thought I asked for agreement with the document as presented with the change by Dr. Chung. All those in agreement, please raise your hands. Any opposed? Thank you. Thank you, Dr. Chung.
Technically, others may.
Thank you, Dr. Chung. Our final document, get back to that, is interactive and transparent development of evidence-based policies and guidelines. Again, a scheduled four-year review process. Ms. Katidachu, did you want to comment on this as well?
Yes, please. So I added a section on this part based on my background in policy that maybe we should have a policy impact review. So it's just a step that recognizes the mechanisms of assessing the effectiveness and the understanding of our policies after we adopt them. So while it might not be for all policies that we have, but maybe it will be applicable to some of them. And it's simply about, like, let's say we have a policy on something, but we still keep on receiving complaints from patients or even doctors about certain issues that we already have a policy about. So we can use this step to go back and see what is the problem. Maybe there is a problem of understanding, or maybe our policy is not feasible enough for them to practice it in their care to patients. So that was the reason why I added this section. And if you have any questions about it, or if you think that we don't need it in the commission, we are open to any feedback or discussions about this. Thank you, Ms. Blake.
Thank you. Are there any comments or suggestions from anyone in the room or virtually?
I'm still having a hard time understanding step 10, that whole statement written in step 10. Can you elaborate on step 10? I can't understand what it actually says.
Did you hear the request? Did you hear the question? What do you ask?
Step 10, he doesn't understand.
He
wants clarification.
I'm not sure what he's asking for.
If you
Is
look
that
on the
what?
policy,
Oh, yeah,
if you look at the policy, there's it
Ten.
comes up to step 9.
yes.
And then there's step 10, which has been written, and I'm trying to read that whole verbatim and I can't understand what is implying
Okay.
or what it means.
Ms. Khadija, did you hear that request?
Yes, I do. So, okay. So it's about policy impact review. So in policy making, we have what we call policy impact review. And this is just basically trying to see what the impact of the policy that we made. So we can try to understand, make sure that people understand the policies that we already implemented and also how effective they are. So in terms of the commission, it's gonna apply as, let's say we have a policy on certain thing, but we still keep on receiving complaints about that certain issue that we already have a policy on. So this step will help us to go back and see if this policy is like how effective it is, or is it that people don't understand what it is really about, or is it that we have to add some things, or is it that we have to update it, or is it that we have to make some amendment in terms of the language or anything. So it's just about to make sure that the policy is effective and is also understood by the people that we made it for, like our licensed practitioners. So basically, it's just about to see how effective it is. It's just a mechanism of ensuring effectiveness and understanding of policies after they are adopted.
My question is, isn't that inherent in every single policy? That if there are unintended consequences or questions, we revisit the policy for potential revision or further delineation?
Yeah, it can be like the one that we're doing, the every 4 years review is part of the impact review.
Mr. Matthews?
Just to point out, yes, I agree that it's part of, it should be part of the policy development process. It's not an explicit stated piece.
Yeah.
So, I mean, there are policies that are on my own pet peeve list where we've just adopted them and just let them go, you know, and we don't really see them except every 4 years. Another one that didn't was, say, the telemedicine policy, where once we adopted the guidance document, it was brought to our attention that we need to address some other things. And so we were able to bring that back. There's an analog on the discipline side, where when you're about to do a summary restriction or summary action, we go out and we do an impact review of what may occur should we take this action. That started back with certain pain clinic actions that we took. And so this is, I would say, a natural progression to at least put it front of mind that we need to make sure that when we are adopting these policies, we are able to respond quicker than every 4 years.
There,
So, Mr. Matthews, are you speaking in support of this step 10?
I am.
one thing that that was pointed out to me is after the policy has been adopted, not is been adopted in the way it's written.
Yeah, I think that was all part of my confusion because I was
Probably
not.
why you were, yeah, it was, okay,
Oh, okay.
thank you.
So then my next question is, do we intend to add this statement to every single policy for the
No,
commission?
This is just your guidance document on how we develop policies. So this is just process.
Can I make just an editorial comment on, it's a little unclear to say, I like it, actually, I like the sentence. It's a little unclear to say we can. I think most policies, we need to define who that we is. It might be a good idea to say, like, is it the commission? Is it the, a specific person or an entity or a position that would do that? And instead of saying can, you may want to better define like may or shall or something like that, because can just means that it's possible to do. You may want to specify, because it makes sense that in some instances, but not all, the commission shall outline or something like that. I think that would be a little more clear.
I agree. Part of this is the state through various executive orders, as well as the Department of Health, has what's called plain talk guidelines. And we're instructed to not refer to us as the, amorphous organization and say we and make it more friendly. But I totally see your point, and I would support changing it to the WMC may.
So are you okay with that, Dr. Chung, as it sits? Yeah, understood. I was looking to see if we could wordsmith the sentence to take we out completely and just wordsmith it, but are there any other questions, or are we okay with this changing is to has as it sits? Any other comments?
And May.
And may. We may outline, so after the policy has been adopted, in some instances, not all, we may outline how the policies will be monitored, et cetera.
A slight suggestion.
Yes.
After the adoption of a policy, in some instances, the WMC may outline how has been is, passive.
All right. Is that better? Okay, is everyone in agreement with the second amended suggestion? Okay. Yes. So, yes. Wordsmithed, but yes, yeah. Yeah, yes, I know that. So we'll need a motion to approve
Motion.
this amendment.
Motion with those changes.
Revision. Second. All in favor? And then secondly, is everyone in agreement with the policy as written with the changes as just approved? Please raise your hands. Any comments virtually? I didn't notice. Okay, that concludes my report. Thank you.
Thank you.
On to the member reports. Any commission members have any items of news or business to report? Dr.
I
Mavundra.
don't know if it is a report, but I was telling my panel yesterday, I got the spam, phone calls from somebody claiming to be from the Washington Medical Council that they want to they're investigating me. But what was interesting, or maybe why I'm highlighting it, is they're now actually using a number that if you call back on that number, it goes back to the commission. So, and it happened, first they called my wife and then they called me on this Tuesday. And so that was interesting.
Yes. And I think the commission put out something warning people of the spam, that the commission will not call you and threaten you by phone.
And we've also worked with both the King County Medical Society and the Washington State Medical Association to let them know, and again, I put an item in the newsletter. This is kind of whack-a-mole. It's rather tireless. Interestingly enough, Dr. Fundura, they also called me using the commission number, and I looked at it and I was like, why is the commission calling me on my personal cell phone? That's odd. 7 times. So it's out there. And it's super unfortunate. We are doing our best. We've let IT know that this is occurring, but for the most part, it's not something that we can control. It's somebody coming in and layering on top of the phone system. But that's very unfortunate. Thank you for bringing that up.
Yes, thank you. It's kind of like somebody calling 911 while in the emergency department. So shame on you, spammers.
Or filing a complaint to us while they're in the emergency department.
Right. On to staff member reports. The written reports are in the packet, starting on page 168. Any other reports?
I've got 2 things. One thing I'd like to highlight for the commission, and then a secondary thing. I will be quick. Caseloads are up. I hope those of you who were able to look at that simple graph that I included year over year over year, caseloads are significantly up. your authorization rate in terms of investigations is relatively stable. It always has been. We're just getting an absolute deluge of complaints. So first, thank you to those of you who were able to take time out of your schedule and do what we're now doing periodically, second CMTs. It's very appreciated. I'll get to some of the results of that work and later in the meeting. But caseloads are up significantly. So please, again, allow time and grace for staff. We are working the best that we possibly can on that note. And we appreciate the collaboration, especially on CMT. We don't. They're up everywhere, across the board, not even just healthcare, just everywhere. HCA. Anyways. Secondly, I have some very welcome news. And I promised him I would be brief. But our own Mike Farrell has received the Homan Award from the Administrative Law Section of the Washington State Bar Association. That's the body that licenses and regulates attorneys. The Homan Award recognizes an individual who has made outstanding contributions to the improvement or application of administrative law. Recognition from one's peers and colleagues is always a marvelous thing. And when your colleagues and peers are attorneys, that's pretty much the highest praise you can possibly get, because we are notoriously critical of our brethren, as anyone will tell you. I'm going to read just a tiny bit of the nomination form that it came through. Mike hasn't received the award yet. That'll come a little bit later this fall. There's usually a dinner and a short, I don't know how short, maybe a roast of Mike. This is part of the nomination. Mike began his 34-year tenure with the Medical Commission as a staff attorney in 1991. He has served many different roles: legal manager, policy development manager. Now, as he, of course, has the supervising staff attorney hat. Along the way, Mike has been a steady force of leadership and mentorship. He currently supervises 6 staff attorneys, generously sharing his institutional knowledge and Irish wit. His collaborative style and commitment to nurturing talent make him an ideal leader and mentor. His efforts to support autonomy through the Commission's pilot project and to shape policy through dozens of guidelines, policies, and procedures have left a lasting institutional legacy. Mike is a nationally respected resource in the field of administrative medical regulation. He is a sought-after speaker, known for his deep knowledge and keen judgment. I will also say, as his colleague since the day I began at the department, his principled approach is kind of renowned. He, in his current positions, teaches that and shows that. He is an outstanding attorney, and I just wanted to let you all know that he was recognized by the Bar Association. So congratulations. That's all I have for this item, Dr. Murphy.
Thank you. Heather, do you have a report? And back to Mr. Kiernan for the final item on our agenda, the 2025 performance measures.
So I talk frequently with the staff, and on a daily basis, this commission staff comes to work and does an outstanding job. Over the last year, we have been confronted with a number of pretty deep challenges. The change in administration down in downtown Olympia, the change in administration in DC. The state budget process was a very long, drawn-out ordeal that caused a lot of anxiety throughout the state workforce. In addition to that, as I'm sure you most of you are aware, we are undergoing a pretty significant transformation in terms of the background database that we use to license and almost all of our regulation in terms of investigations and legal work. The staff has weathered that challenge. And I want to highlight this for you. I don't know if you have access to it, but I would highly recommend that you go and look. On an annual basis, based around fiscal year, we are evaluated by the department against our contemporaries in terms of how well we do on quantitative performance measures. Those measures typically revolve around the amount of time it takes us to do something. There's not, especially in this world, there's not really a wonderful tool for evaluating quality. But I want to highlight, in the face of all of that, all of those challenges and not a small amount of adversity, the staff has performed extraordinarily well over the last fiscal year. One of our main performance measures is how quickly we issue licenses. And by that, we track, once we have final documentation where our performance measure says within 14 days, that license goes out the door. Our goal is 77% of the time meeting that. Despite all the challenges that we have experienced with Helms, a significant uptake in just the number of applications, this last fiscal year, we were at 98%. That is extraordinary. A second note on licensing, compared to our neighbors, we take well under the average amount of time. Our general average is about 6 weeks from start to finish in order the amount of time it takes us to issue a license. That includes gathering background documentation, talking to people, making sure they've got everything, as well as actually issuing the license. 6 weeks. The national average is 8. Our neighbors to the south, 12. Our neighbors to the east, 14 weeks. And California has come a long way, and they're still only at 7. So again, a nice round of applause for our licensing staff who have done extraordinary work. Performance measure 2.1 measures how quickly we get a complaint and get it in front of you all for review. Our performance measure says that we have to be doing that within 21 days, 21 calendar days. Our goal is once again 77%. Over this last year, even with a drastic uptake in the number of complaints that we've received, we were at 99.5%. So that's Chris Waterman's staff. A nice round of applause, please. I have 2 more. Our performance measure for investigations. Within 170 days, we are supposed to have the investigation completed and closed and transferred over to you all as RCMs and legal to review. Our performance measure says that that needs to be at 77%. We finished this last year less than a percentage point off of that, despite a significant increase, as I mentioned, in the number of complaints and investigations that you all authorized. This is Frida's team, along with Adam and all the investigators. So I would like to say thank you again to them and recognize their efforts. And then for my previous home base in legal, this is a measure that historically we have had some struggles with. It basically says that once the investigation is completed and to you all, we will go through case disposition. So what we did yesterday on those Thursdays, we are supposed to be able to do that and have it completed in varying measures within 140 days. Our measure is that we don't want more than 23% of those cases to go past that timeline in terms of timeliness. And this last year, we were at 10. So again, an incredible performance by Mike and Rick and Jen and all the staff in legal. Thank you. So I'll finish with this. For the benefit of the rest of the commissioners, when I talked to the executive committee about these, they were like, wow, that's pretty impressive. And I agree. So as a special bit of recognition for the staff, I'm going to ask for one last round of applause, but we also have cake. So once we're done here, we can have some cake. We have a little bit of time before Dr. Bundy speaks in 15 minutes. But I wanted to lead all of you in saying thank you to all of these folks who do this work with very little recognition and a ton of torrent, sometimes abuse from outside. But we did extraordinarily well in really challenging circumstances. So thank you.
And on that happy note, the meeting is adjourned.